and the same power of making needful rules respecting the territory is, in precisely the same language, applied to the other property belonging to the United States, associating the power over the territory in this respect with the power over movable or personal property, that is, the ships, arms, and munitions of war, which then belonged in common to the state sovereignties. And it will hardly be said that this power, in relation to the last-mentioned objects, was deemed necessary to be thus specially given to the new government, in order to authorize it to make needful rules and regulations respecting the ships it might itself build, or arms and munitions of war it might itself manufacture, or provide for the public service. No one, it is believed, would think a moment of deriving the power of Congress to make needful rules and regulations in relation to property of this kind from this clause of the Constitution. Nor can it, upon any fair construction, be applied to any property but that which the new government was about to receive from the Confederated States. And if this be true as to this property, it must be equally true and limited as to the territory, which is so carefully and precisely coupled with it, and like it referred to as property in the power granted. The concluding words of the clause appear to render this construction irresistible, for, after the provisions we have mentioned, it proceeds to say that nothing in the Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Now, as we have before said, all of the states, except North Carolina and Georgia, had made the cession before the Constitution was adopted, according to the resolution of Congress of October 10, 1780. The claims of other states that the unappropriated lands in these two states should be applied to the common benefit, in like manner, was still insisted on, but refused by the states. And this member of the clause in question evidently applies to them, and can apply to nothing else. It was to exclude the conclusion that either party, by adopting the Constitution, would surrender what they deem their rights. And when the latter provision relates so obviously to the unappropriated lands not yet ceded by the states, and the first clause makes provision for those then actually ceded, it is impossible, by any just rule of construction, to make the first provision general and extend to all territories, which the federal government might in any way afterwards acquire, when the latter is plainly and unequivocally confined to a particular territory, which was a part of the same controversy, and involved in the same dispute, and depended upon the same principles. The union of the two provisions in the same clause shows that they were kindred subjects, and that the whole clause is local, and relates only to lands within the limits of the United States which had been or then were claimed by a state, and that no other territory was in the mind of the framers of the Constitution, or intended to be embraced in it. Upon any other construction it would be impossible to account for the insertion of the last provision in the place where it is found, or to comprehend why, or for what object, it was associated with the previous provision. This view of the subject is confirmed by the manner in which the present government of the United States dealt with the subject as soon as it came into existence. It must be borne in mind that the same states that formed the Confederation also formed and adopted the new government, to which so large a portion of their former sovereign powers were surrendered. It must also be borne in mind that all of these same states which had then ratified the new Constitution were represented in the Congress which passed the first law for the government of this territory, and many of the members of that legislative body had been deputies from the states under the Confederation, had united in adopting the Ordinance of 1787, and assisted in forming the new government under which they were then acting, and whose powers they were then exercising. And it is obvious from the law they passed to carry into effect the principles and provisions of the ordinance that they regarded it as the act of the states done in the exercise of their legitimate powers at the time. The new government took the territory as it found it and in the condition in which it was transferred, and did not attempt to undo anything that had been done. And, among the earliest laws passed under the new government, is one reviving the Ordinance of 1787, which had become inoperative and a nullity upon the adoption of the Constitution. Tift's law introduces no new form or principles for its government, but recite, in the preamble, that it is passed in order that this ordinance may continue to have full effect, and proceeds to make only those rules and regulations which were needful to adapt it to the new government, into whose hands the power had fallen. It appears, therefore, that this Congress regarded the purposes to which the land in this territory was to be applied, and the form of government and principles of jurisprudence which were to prevail there, while it remained in the territorial state, as already determined on by the states when they had full power and right to make the decision, and that the new government, having received it in this condition, ought to carry substantially into effect the plans and principles which had been previously adopted by the states, and which, no doubt, the states anticipated when they surrendered their power to the new government. And if we regard this clause of the Constitution as pointing to this territory, with a territorial government already established in it, which had been ceded to the states for the purposes hereinbefore mentioned, every word in it is perfectly appropriate and easily understood, and the provisions it contains are in perfect harmony with the objects for which it was ceded, and with the condition of its government as a territory at the time. We can, then, easily account for the manner in which the first Congress legislated on the subject, and can also understand why this power over the territory was associated in the same clause with the other property of the United States, and subjected to the like power of making needful rules and regulations. But if the clause is construed in the expanded sense contended for, so as to embrace any territory acquired from a foreign nation by the present government, and to give it in such territory a despotic and unlimited power over persons and property, such as the Confederated States might exercise in their common property, it would be difficult to account for the phraseology used, when compared with other grants of power, and also for its association with the other provisions in the same clause. The Constitution has always been remarkable for the felicity of its arrangement of different subjects, and the perspicuity and appropriateness of the language it uses. But if the clause is construed to extend to territory acquired by the present government from a foreign nation, outside of the limits of any charter from the British government, to a colony, it would be difficult to say why it was deemed necessary to give the government the power to sell any vacant lands belonging to the sovereignty which might be found within it, and if this was necessary, why the grant of this power should precede the power to legislate over it and establish a government there, and still more difficult to say why it was deemed necessary so specially and particularly to grant the power to make needful rules and regulations in relation to any personal or movable property it might acquire there. For the words "other property" necessarily, by every known rule of interpretation, must mean property of a different description from territory or land, and the difficulty will perhaps be insurmountable in endeavoring to account for the last member of the sentence, which provides that nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state, or to say how any particular state could have claims in or to a territory ceded by a foreign government, or to account for associating this provision with the preceding provisions of the clause, with which it would appear to have no connection. The words "needful rules and regulations" would seem, also, to have been cautiously used for some definite object. They are not the words usually employed by statesmen when they mean to give the powers of sovereignty, or to establish a government, or to authorize its establishment. Thus, in the law to renew and keep alive the Ordinance of 1787, and to re-establish the government, the title of the law is "An Act to provide for the government of the territory northwest of the River Ohio," and, in the Constitution, when granting the power to legislate over the territory that may be selected for the seat of government independently of a state, it does not say Congress shall have power to make all needful rules and regulations respecting the territory, but it declares that Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district, not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States. The words "rules and regulations" are usually employed in the Constitution in speaking of the same particular specified power which it means to confer on the government, and not, as we have seen, when granting general powers of legislation, as, for example, in the particular power to Congress to make rules for the government and regulation of the land and naval forces, or the particular and specific power to regulate commerce, to establish an uniform rule of naturalization, to coin money and regulate the value thereof, and to construe the words of which we are speaking as a general and unlimited grant of sovereignty over territories which the government might afterwards acquire, is to use them in a sense and for a purpose for which they were not used in any other part of the instrument. But if confined to a particular territory, in which a government and laws had already been established, but which would require some alterations to adapt it to the new government, the words are peculiarly applicable and appropriate for that purpose.